Denzel Spikes.
Yes, ma'am.
Okay, you're Denzel Spikes.
Yes, ma'am.
Will your client waive the formal reading of the motion and the indictment?
He does, yes.
Judge, we'll just proceed on count one. I mean, on allegation number one, we'll abandon the rest. That is the condition.
Mr. Spikes, in cause number 25, DCCR 0921, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from April 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents in that case that have your signature on them that the state's marked as exhibit number 1. I'm going to need some explanation.
On
The punishment,
his 3, Judge,
he's on probation for aggravated assault with a deadly weapon, commits another one.
just the newest one was not as egregious as it seems. It was a kind of a mutual combat, but
Okay, let me look at the,
therefore we're proceeding on that with the lower offer due to the nature of it, but not to continue him on probation.
okay, give me a second. So give me just a second, I'm going through a couple things. Okay. All right, so I have, again, some paperwork here that has your signature on it. Did you go over that with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Look at one more thing before I do this. Let's see, 24. I'm printing something. Bless you.
Thank you.
I'm just looking now at the PC from the original case. I'm looking at the PC from the new case. Let me see if I can go back. I'm also going to take a look real quick at the PSI. I'm just not feeling real comfortable with that low. I understand in the new case, potentially some issues if there was some mutual combat, but the underlying offense and the fact that we're resorting to the same thing and grabbing things and beating people with them is concerning. No criminal history. All right, state tenders number 1 in 25 DCCR 0921.
No objection, Judge.
It's admitted. Any evidence Mr. Spikes is not competent?
No, Judge.
All right, sir. In cause number 25 DCCR 0921, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1642, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges in the state's elected to proceed on count 1 only. It alleges that you committed the new offense of aggravated assault that we just with a deadly weapon, the one that we just went through, April 29th of 2025. And is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily? And did you plead true to that count because it's actually true? I have here on the tablet also some paperwork in that case that has your signature on it. Before you signed it, did you go over it with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, again, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection, Judge.
It's admitted. Mr. Spikes, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in each of these cases. I'm handing you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here. Ms. Richmond, in cause number 24, DCCR 2306, you're charged with the state jail felony offense of theft with previous theft convictions from September 9th of 2024. The indictment alleges you were previously convicted of theft June 21st of 2019. And then after that was final, you were convicted of theft in 2 cases on the same date, March 21st of 2024 in Bell County, and then again April 10th of 2024 in McLennan County, Texas, and May 31st of 2024 in Collin County, Texas. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And are those prior convictions true?
Yes, ma'am.
What are the outcome of those last few, 2024 cases?
Judge, I've got the one with 2023 in Hayes County. Is that the one? I believe that. Is that
I don't even have a 2023 Hayes County in here. I've got
I've got
two in Bell County, one in McLennan, and one in Collin.
Colin. We got 200 days in county jail,
Okay.
and let me pull the Bell County. Bell County was 9 months.
What about McLennan County?
I believe
Okay.
most of these were punished as a misdemeanor,
Okay.
1244. Judge.
Well, you've got one, the Bell County's out of a district court,
Yes, ma'am.
and the Collin County's out of a district court, which they could have pled them down, but those are both.
This is a state jail. The Bell County was the one in 2024. It's 9 months state jail. And the Collin County one, like you said. I know. The Collin County was a 1244 to be specific, Judge.
Okay. Let me look at something. I don't think I like it. God, these are so hard to read. I'm printing the PC. I can't see it. Okay, PC. So there's a case from 2017 here out of this court for a 2-year term in prison. What was that for?
No, I had 2 years probation, and then when I went to jail, I had got some jail time with a 1224 I don't know how much it was, but
So what I'm looking at here, which is even more than what's included on that indictment,
Yes, ma'am.
shows a 2017 conviction for theft here in Jefferson County, a 2023 in Collin County, a 2023 later that year in San Marcos.
Hayes
I
County.
was
Hayes
in jail
County.
that whole time.
I don't care if you're in jail. I care that you're continuing to steal, and that I'm not sure that this deal that you've made is sufficient for what I think, for what you've been doing. So we're not talking about a long time ago. We're talking about the last 2 years. So going from,
This is a critical turning point. The judge isn't rejecting the plea outright. She's signaling that the proposed sentence may be too lenient given the defendant's repeated theft convictions across multiple counties. Before accepting any agreement, judges have the authority to ensure the punishment truly reflects the pattern of criminal behavior. What do you think? Should repeat offenders receive tougher sentences, or does everyone deserve another chance?
literally from county to county to county. So we've got Collin County, Hayes County, then we're into 2024 where there's 3 convictions, one in McLennan County, one in Belton County, one in Kaufman County. And we're back here with an offense date. So the offense date here was 9/9, which is actually of 24.
Yes, ma'am.
Okay. So at least that one was before the Kaufman County. So you went from here and then you traveled to Kaufman County within 3 days, got another case there. Or at least you had it before and that was the conviction date. Yeah, nope. I will keep the paperwork. Y'all can go visit. I don't think 12 months is appropriate. Somewhere There's got to be a little more than that, in my opinion. Otherwise, obviously, jail time has not been sufficient to deter Miss Richmond from going county to county and stealing places. So y'all take another look at it. I won't delete it. So if y'all come up with something, I can make that adjustment. If not, if you need some time, I'll reset it and then y'all can talk.
Yes, ma'am.
All right, you're Andre Williams III. And this, the second, I'm sorry, the second. This is cause number 24 DCCR 1539. Mr. Williams charged with tampering or fabricating with physical evidence. And cause number 24 DCCR 2286 charged with murder. We're here on an announcement. Mr. Vasquez has also filed a request for me to attach some records, some Social Security records.
Yeah, sure.
I've signed an order already ordering those, and they're not complying, Social Security Administration, with.
You signed an order on September